Can you please look up this thing?
See if we can figure out something.
Hi. All good. Yes, I'm connected to everything. Oh, I have a ranty rant about this. I have a big rant, but I'm going to give a few minutes. Why does it say 0 when you're very clearly here, Lilith? Like I can see that you're in the stream. Let's just move that over there. Go to this guy. And that over there. And that over there. I'm busy recording this Florida thing. But I'm recording in 2 times speed. So I genuinely hope that I can tidy up the audio. I'm sure I can. But I'm worried that it's going to be kind of weird, you know, when you speed something up and then you slow down afterwards. But this judge removes everything so fast. And I don't know exactly what's happening in this trial. All I know is that the beginning, they were saying something about him not showing up, him being in hospital. Wild. So I'm hoping. It's been going for 1 hour 15 on 2 times speed, and it's nearly live. If he cuts the stream before I get the end result, I'm going to be so annoyed. Hey, Lil Miss. Oh, that's what I wanted to do. I wanted to set up the redirect to Recovery Addict now because I am almost guaranteed we're going to have to do a very fast shift over there. Oh, sorry, Lil Miss. I had it sped up. Did I maybe have it on 1.25? Maybe it was the second time. Let's see what our favorite Friday judge is doing. Let me just quickly let him know I sent an email. So, Lil Miss, I feel you. It is horrible. You can't. Fuzzy Texas is in Judge Fleischer's chat. Okay, let's close this. I should probably have it on just in case because I needed to let them know. Bye. Oh. I just hope there's nothing awful in theirs. Viewers are welcoming Judge Fleischer back to the stream, commenting on today's docket while Judge Fleischer is acknowledging the viewers. Is anyone Afrikaans in stream? I don't see anyone that I know is Afrikaans. I'm trying to say practice. What is practice in Afrikaans? Little Miss, I get it for some and then I don't get it for others. It's so weird. Why didn't I push play at the same time? Then we can watch and chat. Wow, what is practice? Gebruik. I've been using it a lot. Has it turned on that stabilized
who's
volume?
next?
Rolled it over to today.
2501.
Now I need to know. Thank you, Don.
Thurman.
Gosh. Dololo Afrikaans is all I could think of.
2501.
Yeah,
Page 7.
I decided to just change the whole sentence.
Blaze.
Can't chat and show you guys, like it's going to show this at the bottom. Just want to see.
2501.
Judge Carl's approaching on Yonka.
Hey.
Didn't realize she was here.
Very nice.
Come up, Miss Yonker.
She's in
I have her
custody.
in custody, Your Honor. She's
Oh.
in custody.
She's in custody for felony VPO.
Actually, pause. We have a few options. One, we can do a Baldwin recap ADHD style, move through it very quick, fast. I've cut like just the important parts, or we can watch Judge Fleischer. We can watch Judge Fleischer later in the evening. Either one of the two, but I know that a lot of people missed a lot of Baldwin today, and I can't watch like 4 hours. So I've got like 46 minutes of a highlights reel. Maybe I should do a poll.
Bring her out.
That's the one you were texting me about yesterday. I told you she's in jail. I wasn't aware that she was on the docket yesterday.
Who else, Victoria? Who's next?
Oh, next is page 11, Jones.
2501.
Felt so clear the first time.
2501. And then the one other. Okay, who's next?
Page 13 and 14, Lane. Except for Raymond on the 8th. Rolled it over today.
2501.
Actually, I want to close chat.
Yeah. And then the one under it, long. Yeah, same thing.
Little Miss.
How's
I
jail?
can't do that because that's what Recovery Addict's going to do.
Ms. Yonker, you had an assault family member with us. You've now picked up the violation of a protective order. And they filed it as a felony. You're looking at 2 to 10 in the penitentiary. I don't know what happened. I'd like to know. That's why I brought you out, because you're still on bond in our case, and I want to know whether that should be yanked or not. I don't know what happened, but can you please?
HPD was dispatched just before 1 a.m. on July 4th to the Belfort condos in Harris County, Texas. The complaining witness is the defendant's former boyfriend. The complaining witness has a protective order prohibiting the defendant from having harassing or threatening contact with him and prohibiting her from being within 200 feet of the defendant's residence at Belfort. The complaining witness states that the defendant showed up at his home and began kicking and banging on his door for approximately 3 minutes. When officers made contact with the defendant, she stated she had come to pick up her belongings. This is the second violation, and the defendant has previously returned to the complaining witness residence on July 2nd.
So they caught her at the place? Do you know or no? You know, at some point, Ms. Yonker, you're gonna get it. You can't just continue to do what you're doing. That's why we have, it's not fun. It's not. But I'm now gonna revoke your bond in our case as well. And I'm gonna raise it up to 5,001.
Can I talk?
First, I would have you talk to Carl to see whether that's something that you should, because I don't want you to say something. I've got a bunch of DAs here, Ms. Yonker, and I don't want you to say something that's going to further, hurt your case as it is.
Your Honor, if I may.
Of course.
Ms. Yonker, I visited with her when I was assigned to her case. I told her, and she understood not to go over there to her residence, to his residence without escort by police authority to get her property back. However, she did text me and call me a couple of days thereafter telling me that Mr. Stone, who's the complaining witness, had thrown her property or belongings in the Dempsey dumpster nearby and that she couldn't come and get it. And she apparently did go by there to try to get her property back on the July 2nd date, which is about the same time period that we're talking about. She received a text or phone call from a third party to go by there to get her belongings. And that's when
I told you,
that is
no
what
one can authorize you to violate this.
he can't. And the only,
And what is so important? What piece of property is so important that you're willing to risk going to jail and up to 10 years? Do you have some kind of disco ball that's made of gold? What's so important?
The thing is, but I was under the impression that the cops were there and he
You
said
mean
that
that poof and magic, the cops are just going to show up? You know what they say about assumptions, Ms. Yonker? Unless you call them and make an arrangement for them to meet you there, they're not going to magically appear like.
4 hours for them to come to me, and I almost ended up in jail. Like, I need all the cop cams of everything pulled. I don't know why the ending of the report doesn't tell you what really happened when I pulled up to the thing with him, because he called me and told me that I
You're
could
not
come
even
get my
supposed to have
stuff.
contact with him.
Yes, sir.
I told you, if he calls you, hang up. If he texts you, do not reply. We tell you these things to put you on notice of what you can and can't do.
Yes, sir.
At the very minimum, you could have called a friend and had them go get the stuff for you if it's that important to you. And now, do you have anyone that's going to post the money for you?
Honor, she's got a $30,000 bond at the felony court, so I don't anticipate, I've been in contact with several people, but nobody's been forthcoming and posting a $30,000 bond.
I
So-
was out on bond, and he hired my bond yesterday because I didn't know whenever.
Isn't she from you're from another state as well, right? You
No, she's
moved
from-
down here because of him.
Jefferson County is kind of another state almost, but not quite.
Yeah. not
No, I
funny.
thought, aren't you not from another state or
She's
something?
from Beaumont.
But I talked in court when everybody was talking, so he raised my bond. I didn't know I wasn't supposed to talk because I was asking a question, because at the end of the report it doesn't say everything that really happened, because I was not caught on the
It
property.
doesn't matter. That's the thing. You cannot justify violating a court order. You either
sir.
do or you don't.
Yes, sir.
That's it. So I'm gonna revoke it, sitting at 5,001. If you're able to make the bond upstairs, or if they reduce it or something like that, come back, talk to me. But I'm issuing a protective order now, right now. And I want you to understand, if you violate this, or if you violate this now, they will hold you at zero bond, no bond. So I would be very, very careful. No means no, Ms. Yonker.
I understand.
I hope you get it now.
I did with the felony charge.
Yeah, if you're gonna revoke it, you raise it only to 1,000 as opposed to 5,000 because she already has a $30,000 bond. So,
I'll do 2501.
thank you, Judge.
And then you let me know if she's,
We need some relief there after she's able to get some relief in the felony court. Thank you.
look, Ms. Yonker.
She has to find something.
Trinidad, you're still here. Why? Oh, okay. Who'd you got? Oh, Mr. Robertson?
You had an
Reset it.
ankle monitor or what?
Yeah, I put an ankle monitor, told him not go within 200 feet of this lady that's been terrorizing at the 7-Eleven. Just stay away, no weapons. For sure. Whatever you want, baby. 2501. No, no, she's not gonna, no. We're good. Hey,
Before he starts the next one, the question on the poll is, which judge would you like to watch? 60% say this one, 20% Simpson, 20% Middleton, 0 Thurston Small Claims, which is fine because Thurston Small Claims is kind of one that I threw in there, but it's actually a better one for me to chop like good parts because a lot of it's just like super boring. But I just want to double check because there's only 5 votes that everyone has voted. Jess said it doesn't matter which. I can't vote. My vote would be Simpson just because, well, to be honest, yeah, my vote would be Simpson because YouTube likes Judge Simpson. I like Judge Simpson, but it means that like a lot of people seem to find the video. I don't know why. But I'm not bothered. Judge Fleischer is perfect for a Friday afternoon. I want to do whatever won't use brain cells, basically, because it's like 10 past 10 and my brain is so tired. 10 past 8, not 10. 8.
hi,
Mr. Preacher, can I have you signed, Mr. Vasquez, a PR bond?
okay,
Again,
for sure.
Little Miss, I agree. And today's Landlord-tenant, which I enjoy, but I know a lot of other people don't. They find it quite boring. But I like Landlord-tenant just because I've been a tenant with so many problems. Such awful landlords. Yeah, 2010, I read like 1010. Here, he's probably replying in chat, but you can't see because it's still live. Making friendly banter. Yeah, there. Guys. Phone popping into our current landlords are fantastic. Yeah, our current landlords are amazing. And the one before that was amazing as well.
Tommy.
So when we're dealing with the landlord, they're amazing. When we're dealing with agents, that's when we seem to have Not that much fun.
How you doing?
What's up?
He's going to third grade. As going to the
Fantastic.
second
Wonderful.
year.
You're in good hands, man. This guy's a junkyard dog right here.
There you go.
There's no better way. That's the way you do it, man.
There you go.
Take your clients, you represent them to the best and to the fullest of your ability, because that's.
I
what it
still
is. That's what
count.
Makes a good lawyer.
I
right?
mod my own
That's
chat.
Ruben. Really? How's it going? You doing well?
I'm all right. I mean, I think it's the most depressing and worrying time of my life, to be honest. I enjoy it though. I enjoy the challenge, and
If
I'm
you
looking forward
treat
to
it-
everything else.
If you treat it good, it will pay you back in dividends. I promise you. You work hard, do your research, do what you're supposed to do. I mean, there's no better profession in the world. I'm telling you, you can make so much money. It's sick. It's just how hard you're willing to work and how zealously you represent your clients. And I'm telling you, I think it's crazy how much, because at the end of the day, it's fun learning, it's fun knowing stuff and going places, but this is what life's about, right? This and getting to know people and schmoozing, and that's what life is. And being a lawyer, there's no better way, really.
Appreciate that.
Are we doing a plea? Are we doing a plea on a sick chin or what? Yeah, okay,
I didn't have fun with anything yet, 'cause I didn't know that.
okay, come on.
I know, he's gonna go have a seat.
Mr. Live to know.
I just knew that you had a translator, that's all I need from it.
Dutch, can you sign the, on?
Thumbnail things.
Okay, Tracy, it's signed.
Oh, sorry.
Hey, Pavel, can you sign an MRP, please? What's that now?
0.
Really?
Yeah, this is something, they don't have no funds.
Okay, 5,001.
But it didn't matter.
So on this one, are they dismissing one and then we're waiting to the other one? Okay.
We interrupt this broadcast to check out what this judge is doing because he deletes things very fast. So we're going to have to watch quick fast.
Ready? So this is 24-00706 at live.
Good afternoon, Your Honor. May I please report sentence? Kerry Phillips, appearing on behalf of Ms. Michelle Nacy, who is standing to my right. Would you identify yourself now?
Michelle Nacy.
It's mid time set for an exam. Are people ready to proceed? Yes, Your Honor. All right, first witness. People call Officer Love.
If it's boring, we'll bounce.
If you raise your hand, you solemnly swear or affirm testimony. The whole truth and nothing but the truth.
I do.
And do you have to state your first and last name, spelling and bold?
It is John Love, John Love.
Go ahead, Mr. Cassidy.
Where are you employed? With the city of Royal for the Royal Police Department.
And what is your position there?
I'm a police officer.
How long have you been employed in that capacity?
Just over 10 years now.
Direct your attention to April 14, 2024 at around 9:19 a.m. Were you working your official capacity as a Royal Police Officer?
Yes, I was.
And on that date, how do you recall what you were doing?
I was dispatched to a
woman passed out in the vehicle at Tim Hortons.
That's
Oops.
2214 East 11 Mile Road.
Correct.
The city of that location.
Yes, I did.
What if anything did you do upon arriving?
We observed a silver sedan. That's the car that was indicated. That was a silver Toyota. And then saw it parked next to the building and we approached that vehicle.
Okay, were you with other officers?
Yes,
Who were you with?
Officer Canals.
Okay. When you approached the vehicle, were you able to determine if there were any occupants in it?
Yes, there is one lone occupant in the driver's seat.
And did you get a clear look at that individual?
Yes.
Would you recognize that person at some again?
Yes.
Do you see that person in the courtroom today?
Yes.
Can you point to an identifying article of clothing that they're wearing?
Flower or leaf dress?
Your Honor, the record reflects the identified defendant.
No objection, Your Honor.
Objection and record is ordered.
What if anything happened when you approached the vehicle and saw that?
Originally we approached, we did see Ms. Nacy, she was passed out, head was leaned forward. And then at that time, I also observed a small pile of off-white chunky powder on the armrest. And due to the nature of somebody possibly passed out, what looks to be narcotics in there, Officer Canal started pounding on the window to try and wake her.
Okay, and when you said it looked like she was passed out, you said her head was forward,
Yes.
and was she moving or eyes open?
No, there is no movement.
Okay. When Officer Canal started pounding on the window, what if anything did the defendant do?
Originally he knocked, there was nothing, he hit the window harder and then she kind of sprung forward. Originally tried to start the vehicle. We yelled at her not to start the vehicle. He had announced himself and then I watched her take her right arm. She swiped it back and it knocked all the powder and everything that was on the armrest off.
All right, and at this point, were you concerned about a medical or safety issue?
Originally, yes. Before she woke up and started moving around, we were worried it was a possible overdose.
Okay, what happened after you saw the defendant come to and move all the powder that was on the armrest?
She looked over at Officer Canales, recognized there was an officer, and then he had her step out of the vehicle.
What happened after that?
First, we had to get her second shoe because she didn't have another, she only had one shoe on. And then we had her step out, brought her to the back. You can see there's more powder on there. And then I detained her in the meantime and then escorted her over to our car and requested a female officer for a search.
Okay, what was the defendant's demeanor?
Very confused. She wasn't sure why we were there. I remember we asked her why she was there. She said she had just got off work. Then asked her what time she got off work. It was like 3 a.m. This was 9 a.m. in the morning. And then I wouldn't say hostile, but definitely was not following the orders that I was giving her.
Okay, now, after she was detained, what happened?
I don't detained her to Officer Canales' car. Officer Smith arrived as a female officer to do a search. And then me and Officer Canales went back to the vehicle while she was detained. Can't remember which vehicle he had, and began a search due to the powder that we seen originally sitting on the armrest.
Did you find anything of interest while searching the car?
Yes, we found a little bit more of the powder, not all of it was brushed off. I found more of what looked like the same type of off-white rocky substance on the seat that she was sitting on and on the floorboard in front of her.
Were any of the pieces of powder field tested?
Yes, Officer Canales used a Nick wipe, which is to test for cocaine, just a field test. When it turns blue, it indicates the presence of cocaine. He wiped that some of the substance that we found on the center console, and it did turn blue.
Which indicates positive for cocaine?
Correct.
Okay. Did you locate anything else of evidentiary value in the car?
I found a corner tie. Well, it's the end of a kind of a jeweler's bag that's blue, usually commonly used to hold narcotics. And then I know Officer Canales found it's a crack pipe on the passenger seat and a paper clip, which is commonly used as a push rod to push the chore boy inside it. And then he also found some torn chore boy in the backseat.
All right, and you used a lot of different words, but all things you just described are those items that, based on your training experience, are commonly affiliated with narcotics.
Yes, it's all paraphernalia usually used.
Defendant placed under arrest at this point?
Yes, she was.
What was she arrested for?
Possession of paraphernalia and possession of crack cocaine.
Thank you. No further questions.
Judge,
I'm sorry, quick vote again. The Karen people that we watched, the lady with the scarf that goes back to front is in Judge Simpson's court now. Well, a few minutes ago. Should we head there? Watch that? Do you want to stay here? Teresa, we were at Judge Fleischer, but then I saw this one was live and he deletes his streams straight away. Whereas Fleischer leaves us up and Judge Simpson, I've got screen recording on another one. This is Landlord-tenant, the blonde lady that I said really shouldn't be a lawyer. That one.
have no question. This time we intend to offer no testimony.
All right, you may step down.
The sound is quite tough with this one.
Here, people rest. People believe you better standard of probable cause. I believe that any questions back to the driver effect, and that's the bound over charge.
Judge, I would ask that this matter be dismissed. I don't think there has been a sufficient showing for the purpose of the preliminary examination. The officer testified that they did a field test of what they suspected narcotics. That is a hearsay declaration. I understand that the rules of evidence have been carved out an exception for field tests. Rule 766.11b. The problem is that it's not enough just to say you performed the test. The test has to be properly performed. And I didn't hear enough of a foundation to indicate that the officer that administered the field test had properly performed the field test. He did not indicate what the protocol is. He did not indicate the steps that the officer took to determine what the substance was, other than the fact that he swiped it across the substance. And so I'm objecting based upon the fact that I don't think there's no sufficient showing as to what the nature of the substance was. We do not have a lab test. All we have is just this field test that was taken, and there's been no overnight testimony. I don't want to keep repeating myself, but there's no testimony that the test was properly performed.
Thank you, Mr. Phillips. Mr. Pascal, I would just again indicate as the court knows this is probable cause standard here today. All right. The court heard the testimony from Officer Love. He described a white powdery substance that he observed to be field tested by Officer Noss. I think this officer reference. Saw him use the test, indicated that he saw him swipe that white across the powdery substance that was suspected narcotics. And that it tested blue, or that it turned blue, and that his understanding and knowledge of that test is that when it does turn blue, that is positive for cocaine. This is a probable cause standard here at the preliminary exam. As counsel mentioned, there's exceptions within the Michigan rules of evidence to allow for that type of testimony to be entered for exam purposes only, so it was properly entered. And I do find that it was enough testimony and evidence with regards to that substance to establish that there was probable cause that Ms. Nacy was in possession of cocaine.
Okay, there was enough probable cause she was in possession. That's where I want to be. Oh, stop screen. Everybody's saying, we'll go where you go. So that's okay. I want to go to Judge Simpson. Your browser has lost connection to audio, but it should be back.
Yeah.
You
should be able to.
Sorry about that.
So can you hear?
There?
Yep, I'm here.
Oh, there you are. Okay. How you
Got the
doing?
cover. Good, how about you?
Oh, I cannot hear you. Forward. It's got to be on his end.
Can you hear me now?
Nope. I got Okay,
Oh, you know what? I'm sorry, Your Honor.
hang on. It might be us.
It's us, yeah.
It's
He should be able.
not me, but Ann. You can hear me, right? But I can't hear him.
Okay, well, now it's definitely not.
Okay,
What about now?
all right.
There
There we go. I think.
Technology.
Got it. There you go. All right, sir. I've reviewed your search warrant and the affidavit. If you'd please raise your right hand. Do you solemnly swear or affirm the information contained in the search warrant and affidavit is true to the best of your knowledge, information, and belief?
I do.
All right, very good. I'll sign off on these and we'll get these over to you shortly.
Thank you, sir.
All right, thank you. Stay safe out there, please.
You too. Thanks.
Was that it? We're waiting for
Two
Jerome.
signs on this.
Yes.
Jerome is the name we want.
This was also.
Yes.
All right. Arbor Meadows versus Charles Carter.
No.
All right. And on this matter, this case, the plaintiff had failed to appear. Last time I dismissed the case, you heard what counsel had said. I'm going to grant their motion to reinstate the case. All right. I don't know if you guys had an opportunity to talk about the substance of the case at all.
We did, Your Honor. I provided her with my card. Hopefully before the next hearing, we can have a resolution.
All right. So what I will do is I'm going to grant their motion. And then I'll reset the case. Will next week work for you? Okay.
There's only 17.
July
hours
19th,
back
2024 at
1 p.m.
at 1 p.m. Okay,
All right.
thank you so much. And we did not have, I said it just to Woods versus Johnson, right?
Do you need proposals? I drafted those as well.
That would be
For
great.
each and every one. you want.
Yes, that would be great if we had those. Arbor Meadows versus Kevin Love.
No.
They are not here. Johnson's here. Oh, come on.
Say
Come on
one,
up.
please.
What's your name?
William Johnson.
You heard what counsel had indicated?
Yes, yes.
All right. So I'm going to grant their motion to reinstate the case.
Okay.
Did you have an opportunity to speak with him at all?
Just briefly.
All right. So what I'll do is I'm going to grant the motion to reinstate. I'll set this matter for next week at 1 o'clock.
Okay.
Work for you?
All right, that's fine. But I will say that I'm planning on paying it by the end of the month in full, and I'm starting a new job at a car wash on Saturday. So tomorrow.
Okay, so you're gonna pay it, you think you're gonna get it paid by the 31st?
Yeah. I'll have it completely paid off by the 31st.
All right. So what I'm gonna do is I'll adjourn it to next week, see if you can work something out.
Okay.
So that'll work, okay?
All right.
That'd be great. 1 o'clock on the 19th.
All right. Thank you.
Sir.
Thank you.
Thank you, Judge.
All right, just want to make sure.
You too.
Arbor Meadows versus Love. That motion is granted. The motion to reinstate granted.
Thank you.
And I will adjourn this matter or reset it for the 19th, 2024 at 1 p.m. And then Arbor Meadows versus Carter and Rutledge. Carter and Rutledge, they're not here. Motion to reinstate granted. And I'll reset this matter to July 19th, 2024, 1 p.m. All right, and I don't have the files. If those are the orders. All right, Whitaker Oaks versus Majani Green.
81 P 177 fourth plaintiff, Your Honor.
and also Daniel Keener. Hello,
Hi, sir.
your name?
Marjani Green.
All right, where are we on this case?
Your Honor, Ms. Green indicated that yesterday she dropped off the $1,000 that was ordered to be paid by the 12th at the last hearing. With that credit, there would be, I've not received confirmation of that. She just represented that to me today. With that credit towards the account, there would be a balance of rent of $1,444. With cost of $214, the total would be $1,658.78. That's due and owed.
All right, how are you gonna get this paid?
I did apply for SCR and I submitted that to the court, and I also have an appointment with Hawk for my funding appointment on the 16th.
On the 16th?
Yes.
Okay. Okay, let's see about this so we can see. Between now and then, between now and let's say the 26th, is there a payment you can make at all?
I know I should be able to pay another $1,000 by the 26th. I do believe that the balance is a little bit off from what they have in the office, so I'll be able to know exactly what it is.
What do you
owed. Because the amounts that they have here in court, when I pay the office, they hold on to the money orders. They don't apply them to the account. So I'm just kind of having to keep track of the decrease because it hasn't reflected in their paperwork yet.
Okay.
I know it should be less than $1,600. I don't believe it's that much.
The 1,658 that you gave me and some change, that did not include the 1,000, correct? Or did it? You're subtracting out the 1,000 that she submitted?
That's correct, Your Honor. In June, she did make payments, so I just want to be clear for the record. She made payments in June. Those were credited directly to her account. So there was a $600, a $200, and a $400 payment all on June 14th that were credited. That brought her balance down at the end of the month to $1,436.05. July rent hit. That's where we hit the balance for now. The $1,000 that I don't have confirmation of would be that balance. If it were to be applied, would drop it down to that 1,600.
1,600. Okay. All right.
Thank you for.
Of course.
So how much of what they're saying are you disputing?
I believe that it should be about $1,100 to $1,200 based off of what I've paid. So I'm not sure what else has been added on in the meantime.
Okay, so one of the things that's going to be added on that you may not have accounted for are court costs.
Okay.
Okay, so how much your court cost counts on this?
With two defendants, it's $214 for the filing fee service.
$214?
Yes, sir.
Okay, so that's going to be part of that.
Okay.
That's going to be off. All right, but let's see if we can get you through this. So you
We're
think you
waiting
can
for
pay another
Constance.
1,000 by
And
the 26th?
Yes.
Okay. How much is your monthly run again?
About 1,000. It's 974.
About 1,000. Okay. Okay, so you're gonna pay that by the 26th.
Yes.
Let's try to get that in as early in the day as possible, or if you can pay it on the 25th, that would be great.
Okay.
Okay. And Counsel, I'm going to adjourn this out 2 weeks. The 26th, 2024 at
2 p.m.
At 2 p.m.
Okay.
That's going to bring your balance down around the $700 figure, 658, somewhere around there.
Okay.
But our problem's going to be, we're going to be clicking into August.
Yeah.
Okay. But here's my thought. Okay. Because you're trying to catch up, right?
I am.
And so your next pay, you get paid every 2 weeks. Right?
Yes.
That's where so by the August 9th date, if we just assume that you don't get any assistance whatsoever from anybody, okay? So let's just make that assumption. The 9th, if you can do the same thing with the 1,000, and then if we have to kick it out to the 23rd of August, you should be able to then catch yourself up.
Okay,
Hopefully then we got another week, and then that next week will be the beginning of September, and then you should be,
completely done.
well, you'll be done. You'll be done in August, but then come September, you'll get that check that you can make your September payment
Right,
on time.
yes,
Make sense to you?
yes, it does.
Okay, let's see if we can work it out that way.
Okay,
Okay, so we'll see you in a couple weeks, pay the 1,000, and then we'll move from there.
all right, thank you very much.
You're welcome. Have a great weekend.
I think Constance is the lady that should not be a lawyer.
BO Properties versus Michelle McCree.
Oh, no, I'm gonna have to.
1774 for plaintiff.
Like,
It's okay. If not, I'm gonna grant a judgment to you. All right, who do I have here? I know who I have, but I'll let them put their appearances on, just.
good afternoon, Your Honor. Jane Bassett appearing on behalf of Harold Allen.
And Your Honor, Constance Jones, I'm appearing on behalf of Joan Allen.
Right, and we work this all out.
We are
No, we have
working on it, Your Honor. Ms. Jones has consulted with a Medicaid specialist, an attorney who does Medicaid planning. We're talking about ways to make this work both for Mrs. Allen and for her son Harold. In the meantime, we have filed an answer and a request for a jury trial just to make sure that we have the time to keep working on this.
And Your Honor, I would, even though we are exploring the Medicaid planning issue, and I certainly hope that that can work out, I think it is important to keep moving this on. Mr. Allen, in my view, needs to find other housing. Ms. Bassett indicates that they're attempting that. I haven't heard anything to that effect. And so I need it to continue being set for whatever it needs to be set for. And if that includes a jury trial, then that's what we need to move toward to process the eviction.
My next jury dates are what, August?
August 9th.
August 9th. I can set a final settlement conference in between that time, which it would be, I set a final settlement conference prior to my jury selections.
Your Honor,
So
one moment, let me grab my schedule.
this is the 12th is my selection day.
Correct, yes.
All right.
So when you,
So usually for civil cases, I set final settlement conferences on a Tuesday.
okay,
But those are in person on a Tuesday. So I would set the final settlement for August 6th.
so Your Honor, I am out of town that week.
The whole week?
Yes.
Okay.
I mean, when you set the settlement conference, then what does the jury trial
Then-
occur on the 9th?
The jury selection would occur on August 12th,
Okay,
the Monday.
so
I
I could
it is
do
the
that
week
as long as I could appear by Zoom at the settlement conference, but you may not want that.
No, I have that. Those are all in person. So, because then because of the way the court's calendar is set, my next jury selection isn't until October.
Okay, well,
So,
let's take August 6th date and I will have to find somebody to stand in for me.
All right. Final
And
settlement
that
conference.
is perhaps appropriate anyway, because I am really Joan Allen's guardian and conservator. So I think that I will have to hire
Yeah.
counsel at this point anyway.
Gotcha. Okay. So I'll set final settlement conference in this matter for August 6th, 2024. What time?
9 a.m.
At 9 a.m. And then jury selection if necessary would be August 12th, 2024 at 8:30.
For the jury trial then to occur that week.
Well, the jury, now, the way we work is, then I try to work with counsel and everybody, if we're gonna select, to get a date that everybody can be there and have their witnesses, and we set it. We kind of get a tentative date for jury trial, so that everybody can be there, whatever we're gonna do. So it would likely occur later in August.
All right.
Okay?
Thank you, Your Honor.
All right. Thank you,
Thank you,
folks.
Your Honor.
Great seeing you.
You too.
So I need to try and recap myself. Maybe I can ask ChatGPT to just summarize my video, because it's been a while and I'm not 100% convinced I can in 3 minutes, because that's how long it is till court is back / RA is back. Starting action. But you see what I mean? Like, look, I changed the thumbnail to Judge Simpson. Stream automatically goes like, pew.
Court does call the case. Alec Jerome versus Eric Cassidy. Do I want to call this one right this second? Or
There is a motion attached to it, so maybe.
yeah, can you hold on? Let me just clear these other ones, because you guys may take me, because you guys do.
I was surprised you called us.
Yeah, so was I.
Wait a minute, why is Caroline still hanging on there?
Jacob Properties Management versus Justin Reed.
Good afternoon, Your Honor. On behalf of the plaintiff.
Wait, I'm very confused. Did I have the wrong one? Was that the one where they were swindled by the bank or something? And now this is Jerome?
I know. Mr. McCurdy was going, what? No. Anyway, all right. Okay, folks, where are we on this case?
Your Honor, I spoke with Mr. Reed yesterday. He's been approved for SER, so we are going to ask for an adjournment for 2 weeks to work out a payment plan.
Okay. Okay, so you were approved for SER. How much were you approved for?
I have not been told the total. They were waiting on a ledger from Mr. Jacob.
Gotcha. How many people are in your, that was an SER or Hawk?
Hawk and SER.
So, oh, okay, so you got approved for state emergency relief.
Yes.
You should have gotten notice of how much that is. You don't have that yet? How many people are in your house? 3? So that's gonna be likely around 600 or so. And then you're approved through Hawk?
Yes.
And they did not give a figure because they're gonna be looking at the ledger to try to figure out. Gotcha. Okay, that all makes sense. Okay, you wanna go 2 weeks out and let's see where we are?
That works for us, Your Honor. Thank you.
She didn't pop in. That's okay, because they probably don't know anyway, so. July 26, 2024 at
3 p.m.
At 3 p.m. You come back to pay that,
Okay.
Is somebody
I expected him to do some work.
should do, and so technically he was not a trespasser at that point. He may have, I mean, under a generous definition, he may have exceeded the authority granted.
Very
right, but to really, by technical definition and under my interpretation, to call him a trespasser, no. I mean,
well, I understand. I've been doing this a long time. I got, white hair, but never had a situation where I've had a couple actual trespassers where they just busted the
dead
door.
buster, and those are the technical ones.
I've never had something like where this guy, I asked him to do something, and of course I had to provide him with the ability to go onto the property to do it. And then he,
Yeah, well, it's very, this case was sort of very close to the apartment complexes that hire somebody that give them a unit, although you.
Okay, we've got to move here because it's going to be time now to head over to Recovery Addict.
She doing? What is she doing? Just walking across my well. Alan, take her down. Alan
There's a
Giroux
lot of people
versus
that wouldn't
Eric
mind
Case.
Alan taking them down. Okay, here we go.
We set the motion.
Yeah, so that it's,
Okay,
yes.
okay, that's what I thought. All right. Council, state your appearances.
Donna Tope, I'm here on behalf of the plaintiffs, Alec Jerome and Caroline Jerome. They are here by Zoom.
Yes, I do see that.
Good afternoon, Your Honor. Francine Ovar appearing on behalf of Eric Cassidy. Gail Rosen from University of Michigan Student Legal Services has filed an appearance on behalf of Paula Cassidy. However, Ms. Rosen is at a conference this week, and so we are proceeding without her presence.
All right. I think the first order of business that we have to take up is before it goes any further, is the motion, I think, filed by Ms. Rosen. So I don't know, counsel, if you were going to, well, who was going to argue that motion? She's not here.
I'm fine arguing the motion, Your Honor.
All right. And counsel, you received a copy of the motion? Okay. I did not get a response to the motion, but.
I haven't had a chance to respond, but I will today.
Okay.
Your Honor, I did also mail the motion on Monday and email it as well.
All right. Well, without hearing, I've reviewed the motion and I don't need much argument unless somebody wants to argue. And I guess, Mr. Tope, I would ask why wouldn't you be disqualified as counsel? I guess I'm gonna start there.
That's fine, then, Your Honor.
First, because, sorry about that.
What would
Why wouldn't you be disqualified as counsel in this case?
Your Honor, their counter complaint is this, their complaint or their motion to disqualify me is premature. It's not right. There's no certainty that the cases will go to trial. The plaintiff's right to the legal representation of their choice would be irreparably damaged if their attorney were not there to represent them during preliminary steps before trial. If the case does go to trial, defendants can make the motion then. The defendants claim in their brief that there is a conflict of interest. A conflict of interest does not exist. I, Donna K. Tope, MSJD, has no legal or personal relationship with the defendants in this case. Donna K. Tope, as plaintiff's property managed agent, has no legal or personal duty or legal relationship with the defendants of any kind. The legal brief is an error. Donna K. Tope, MSJD, the plaintiff's attorney, is not a party in any of the Cassidy's legal filings. Their counter complaint is against Alec Jerome, Caroline Jerome, Cambridge Family Holdings Property Management Company, and Donna K. Tope, the Jerome's property management agent. The complaint is a documents case. It is a landlord-tenant case for non-payment of rent and termination of the lease. And that the Cassidys violated several terms of the lease between landlord owners Jerome's and the Cassidys.
Okay, Mr. Let me stop you for a moment.
Mhm.
On some of that, you may be correct. But I think the biggest problem that I see, and there are a number of them, but the biggest problem I see is you representing in a case in which you may be a witness.
And my next point is directly on that point, and that is that the case is based on the Cassidys withholding all rent and utility payments, beginning with those due September 1st. The defendant's defense is limited to the legal basis for the claim that those repairs were so egregious and made the home so unlivable so as to rise to remedy of withholding all rent beginning December 1st. There are 4 different witnesses. They have filed the case against Alec Jerome, Caroline Jerome, Cambridge Family Holdings, and Donna K. Tope. All 4 of those people could be witnesses for any of the evidence.
But counsel, that doesn't negate the fact that you could be a witness.
I'm not an essential witness. There are 3 other people.
But hold on, I think that you are, if what's contained in here is correct. And that is that you're having these conversations with the other parties.
I'm having these conversations. Could you be a little more specific?
Well, but you're arranging certain things. You're the one talking to them. You're the one dealing
As
with
the
them.
agent is, okay.
Right, I get it. I get why you're doing it in that capacity. I don't
Right.
have any issue with
Okay,
that.
I'm just trying to understand.
Right.
What
What
we're
I
talking-
have an issue with are the rules of professional conduct, particularly. And then you representing a party where of rights, because of a conversation that might have ensued, you would be called as the witness. That's a problem.
Okay, the rules of professional conduct, and that is where that is behind what I say, that the brief of a conflict of interest does not exist, is because that an attorney in a party to a suit cannot be a witness. I, Donna K. Tope, MSJD, am not a party to any lawsuit that they have filed.
No. But the rule also indicates you can't be the attorney and witness.
The other 3 parties are the best witnesses because they're the landlords.
But counsel, just by being here the number of times that we've been here, what's clear to me is that you're, just by way of example, you've got conversations or have conversations that you've had with the Cassidys directly, with Eric and Paula Cassidy.
Not as an attorney, only as the property management. And they are all related.
Right. But it almost would be better if you had it as the attorney, because that puts you in a different boat. It's precisely what you just said that causes the problem. You are having these conversations, negotiating with them, imploring them, taking their complaint. Hold on.
I'm not negotiating. I'm just managing the property.
Right. But in that management of the property, you're having the conversations with the tenants.
through their attorneys, always. Now, once these cases began, I do everything through the attorneys as well.
They didn't always have attorneys,
No.
right? You dealt with them directly.
Neither did the Jeromes.
Ms. Tope. I think, let me just be clear about this. I am loath when an attorney comes before the court to disqualify an attorney ever. I just am. I think attorneys, we're in a profession that is in a lot of ways self-governing. So if there is a conflict, I mean, if you just take the basic structure and you say that if I am an attorney in a case and I could be a witness to something in the case, then you almost have to rely upon the attorney not to enter into representation. Now, having said that, and so typically attorneys won't, right? And so I don't like, because I think attorneys have to make that decision a lot of times on their own, right? And so I don't like to get involved in that. But when it's brought before me that an attorney is going to be a witness in the case, and the other reason I don't like it is because sometimes that can be used from a tactical perspective from one side or the other. And so I went through this in great detail. And quite frankly, trying to find a way that would preserve your ability to represent these individuals. That's really how I approach it when I'm reading it, right? Because what I say to myself is, if an attorney isn't supposed to be in a case, the attorney's going to get out of the case. This other side's filing this to get this other attorney out of the case. So I'm going to operate on the presumption that the attorney should be there. When I finish reading this, and then also knowing and having been here and heard the case, I'll be absolutely honest with you. I don't think you can represent the parties in this case, because you are clearly, in my mind, going to be a witness. Now, I'll stop you, hold it before you say anything.
That's if we go to trial.
But here's what I don't want to end up in. But there can be certain points before trial. In the way I operate my cases, where I set them for a final settlement conference.
Right.
And the thing in certain
Yeah, no, I would be acting as their attorney in those pre-trial.
Right. Well, the problem is I may ask for certain representations from the parties. Right. I don't want to.
I understand. I get exactly that. There is a problem there because you would be talking with them from, I get that.
And I don't want to be, so the interesting thing about all lawyers are bound by this, that if I see a violation of the ethical rule,
yeah,
I'm then,
that would be,
hold on, I'm then required to report.
Okay.
So I do not want to be in a position where I have to report you. I don't do that unless I absolutely have to. And
thank you very
not
much.
Want to do that. I wouldn't want to do it to anyone.
So can I just want to suggest that those kinds of, your kinds of reservations, your kinds of concerns would not apply if the Jeromes were representing themselves. And yet they still are going to be witnesses in their counter complaint.
That is absolutely correct.
Okay,
It wouldn't apply to them.
no,
It doesn't.
no, because they're not attorneys under the attorney. Well, I still say that I would like you to wait until we actually come to that Waterloo. But I know that, because we may not, I mean, we were hoping that we could get some kind of meeting of the minds at this discussion that occurred without attorneys at the University of Michigan legal department's discussion, dispute resolution meeting that took place. And we did not. But if a settlement does occur before I have to come in a legal court proceeding representing the Jeromes, then I wouldn't have to disqualify myself from advising
Ms.
them.
Toth, I'm gonna have, I've been doing this a minute.
Yeah.
And I'm just gonna tell you, I'm gonna see it on motions. I'm gonna see that
Got it.
this issue get raised.
Got it.
The moment an affidavit's filed.
Yeah.
We're gonna have a problem,
Yeah.
right?
I totally am understanding your issue.
And so I don't want, everybody has a right to have their cases heard expeditiously to get through them. And I just don't think that can happen in this case.
Given what's
you
going on.
representing them. Because and here's the other part. The other part is this is a summary proceeding and maybe one of the thickest or second thickest I've had this year filed. But summary proceedings operate at a different pace. We operate rather quickly. The moment they file a motion, file an affidavit alleging that you said we got a problem.
Yeah.
And then I have to put it on hold, which is not, quite frankly, in your client's interest. I have to put it on hold, waiting for an attorney to come in to just answer the motion, let alone argue.
Okay.
Because you would place yourself in a quandary by even trying to answer. You follow me?
No, absolutely.
Okay.
Absolutely. I mean, like an arrow to the heart.
Okay. Well, don't put it that way.
No, I just gotta say.
Yeah.
That's what it feels like, but
Okay.
I totally understand.
All right. So I guess my question is, if you, rather than me even ruling on this motion at this time, but if you were, how long would it take for you to find counsel to substitute in?
I will talk with my clients and we will have a speedy discussion because they are on it. And I can get back to you within several days.
Okay. Hey, well, as this side to the Jeromes, based upon the discussion, I realize you guys aren't lawyers, so did you have any questions with anything that the court was saying or anything that was going on there?
Alec, did you want to? I think it's clear. I think I understand what you've said. Thank you, Judge Simpson. And yeah, we can confer and we'll figure it out. There is always a lawyer present. Just because of the nature of the tenants, but we'll find another lawyer that will work and won't cause a conflict. I understand that's super important.
Yes. Okay. So. Yes, ma'am.
You did understand what she said, that in every situation, involving the tenants, there is a lawyer present on their side because Eric is a lawyer and he has sort of, yeah.
Right, and if,
He's
and
inserted lawyerly things into the discussion.
I get it. But
Okay.
But if, Eric, but if he were representing, quite frankly, he might have a problem if he were to step in and represent even his wife in this. He could certainly represent himself. I mean, he could do that. But that's not what this is.
No.
Right. And I get there's always a lawyer involved. Sometimes you throw a stone, there's a lawyer involved. So
Mr. Cassidy is licensed in the state of Texas, not in the state of Michigan.
state of Texas, my condolences. All right, so that's it. So I guess my thought process is to adjourn this out a couple weeks, allow them to substitute an attorney in even before I rule, so that way we're not even trying to do things right now that may cause problems later. But I don't know how you feel about that. We like having you here every couple weeks or so, but
Your Honor, I mean, we really are asking the court to make the decision today, and I think an email that we received last night from Ms. Tope at like 11:30 p.m., coupled with the motion that she filed a few days ago to allow the landlords to repair the property without the tenant's presence, show how integral she is and what a fact witness she is. She's, in our opinion, the only fact witness. We don't need anybody else. Not to mention the fact that most of our counterclaims are against her individually.
Oh, I know.
Emotional distress and whatnot that we're gonna file is against her.
I know.
Individually. And she has a clear conflict of interest because I presume the Jeromes are gonna distance themselves from her and say they haven't authorized the behavior that she's been doing on entering onto their property.
And those are all allegations.
I know. And look, folks. All right. Maybe my problem with being a judge is I'm a lawyer's judge.
Is what?
I'm a lawyer's judge. I love the practice of law and I like watching lawyers practice. And where I don't have to enter into having lawyers do the right thing or whatever, and I don't. I think you had Ms. Tope a certain position that she had. We had that brief interaction we just had now. My understanding is that there will be an attorney substituting in. So what I'm going to do is, this is how I'm going to leave it, because I do understand your point, but you have 7 days to file a substitution of attorney. If not, the court will enter an order granting the disqualification of this. Just do it that way. All right. You're welcome. And I'm not going to proceed on anything else until I have different counsel on this side.
Okay, so they would have to refile my motion that to have the tenants vacate while the landlords do.
No, I mean, I'm not going to require them necessarily to refile. They're going to have to sign something for that motion under the court rules because it has to be their motion.
Okay.
They don't have to absolutely refile it. I'm not.
Excellent.
I mean, there are ways around that notion without causing undue delay.
Yeah.
All right.
Thank you.
So what I will do, and if you would prepare the order that there will be a substitution, right?
Yep.
Or that the court will be granting that. So that order needs to be prepared, submitted to the court. I will adjourn this out 2 weeks. And we will come back. And I'm sorry. Yes, ma'am.
I'm being a little sister. My brother has had his hand raised because he did want to also.
Oh, I'm sorry.
That's okay.
I'm sorry. I wasn't looking at that screen. And I
That's totally
apologize.
cool. Totally cool. Okay.
All right.
Alex.
So you said you were being a little sister when you did that?
Speaking up for my
I wasn't speaking up. I did have my hand raised.
No, it's okay. I have one of those, and you're right. I get him. Big brothers were just quiet until our little sister says, "Gotta say something."
Okay, I'm back.
Go ahead, sir.
Your Honor, the only point of question that I had was related to, we actually came today prepared to make an offer for settlement of the situation related to the payment of all of the back rent, penalties and fees, but absolving the Cassidys of any of the penalty related to the forfeiture or breaking of the lease, which was in the neighborhood of, I believe, $26,000. Does that make a difference in terms of having a discussion or not?
Yeah, no,
Restriction on this in terms of any proposed settlement that we have.
yeah, in the court, its head is not, I'm not even dealing with that. The short part of that is you came to try to look to negotiate it. What I'm going to suggest to you is just hold it for a minute in terms of what position you may want to put forward. Let's get other counsel in to do that who can also look at it. And then if that's still your proposal, certainly there'll be time to submit that to the other side.
Yes.
All right, thank you.
We're heard. Alec, you were heard.
All right? Yes. Okay, so what I'm going to do then is I will adjourn this to July 26th. I set it at 9. You will get a time breakdown as to when it'll be set. It's likely gonna, well, no, what time? will it?
3 p.m.
Oh, it will be set, thank you. At 3 p.m. All right, on the 26th,
July 26th.
3 p.m.
Thank you.
All right, folks. Thank you.
Thank you, Your Honor.
Thank you. All right.
Check the size of their file.
All right. That it for that block?
Yes.
That is. You know what? You can tell her I said this. I don't think Rosen had a conference. I just think she didn't want to come back and see me. I hadn't seen her for ages and then saw her, she was in with Fink, I think. Yeah, hadn't seen her for ages. So
Yeah, Gail's awesome. She actually emailed me last night and said, I wish I could be there tomorrow.
yeah, got it. All right. You guys take care. Courts and races. All right.
Okay. Hi. Lots of people joined. I'm sorry. We have to rush over to Recovery Addict. The guy that I believe pretty strongly framed Hannah Gutierrez Reed is in court, and I need to see that, and I can't be in 2 places at once, unfortunately. But I might have a stream up tomorrow for some casual watching. Let's see. Have a good evening. Maybe see you later. Bye.